Your Excellency, President of Uganda, my Lord Chief Justice, honorable ministers, my lords, ladies and gentlemen, my task this morning is a pleasant one to invite Your Excellency once again to address members of the legal profession. But permit me to make one observation before I invite you, and that is that the gathering you see today is, in my experience, unprecedented. I was chairman of the Law Society for some years, but I have never witnessed a gathering of this size and of such a variety of members of the legal profession as we have today. But that's because I should mention that my period was a time when lawyers spent more time struggling or fighting against oppression and hiding away from the forces of oppression. Mr. President, you have been described as a champion of the freedom for this country. You are yet demonstrating, and I think the turn-up today confirms that you are also championing the rule of law. Mr. President, with those few remarks, I invite you to address the gathering. Thank you.
Mr. Chairman of the Law Society, Chief Justice, and distinguished members, I must first of all say that the speech, the memorandum read by the chairman is a very good one. It makes very constructive suggestions as to how law can be turned into an instrument of liberation. And if I was a member of the Law Society, I would be a leftist in the society. I would not be a rightist. I would be for using the law to more vigorously against crime and against violation of human rights. So I'm happy with the memorandum. You invited me to address you on a topic of my choice. And the topic I intend to talk about is law reform in Uganda from the NRM point of view. Depending on the nature of the state in a given society, law can be an instrument of oppression and exploitation, or of social justice and progress. Law is not synonymous with justice. It's not always synonymous with justice. It can be, but it may not be. What is legal is not necessarily what is just. Law can be used by the strong against the weak, by the rich against the poor, by the minority against the majority. Historically, law has been used by the oppressor against the oppressed. During the slave period, slaves were owned and disposed of like chattels. And it was perfectly legal to own a slave. In those days, you could legally own a slave. And your rights as a slave owner were enforceable in courts of law. The slave had no legal rights to property, to human relations, such as to have a wife and children, and even to life itself. The life of a slave could be taken away by the slave master at will. And it was the legal right of the slave owner to kill his slave. In the United States, it was forbidden by law for the slave to have education. During the feudal period, the feudal lord was legally entitled to the free labor and money of his serfs or vassals whom he permitted to live on his land. During the colonial period, law was used in some colonies to deprive Africans of their land and settle them in reserves. In South Africa, as you know, law is still being used to suppress the blacks and to deny them their political, social, and economic rights. The NRM government is strongly opposed to having laws on our statute books which serve the interests of the minority as against the majority of our people, or which in any way serve to promote injustice or advance backward interests in our society. The place the governments of Obote and Amin accorded law in their order of priorities was, as you all know, very low indeed. They had no respect for the rule of law, and their record of gross violation of human rights through murders, detention without trial, tortures, disappearances, rapes, and robberies is not going to be easily surpassed anywhere in the world. Such governments could hardly have been expected to make any positive changes in the legal setup we inherited, and consequently our law remains 24 years after our independence, largely laws left behind by the colonial government. Obote did not have time to modernize the law. So right now, Obote and his protege, Idi Amin, they had no time to modernize the law. So as of now, some of us are seeing discrepancies between reality, between the desire to have justice and the existing law. We see there's a very big discrepancy, especially we who have just come on the scene from where we were. Because where we were in the bush, we really were serious with human rights. You could not play around. Our law was strongly on the side of the people. But here, we find a very big gap between justice for the population and the law, the state law as it is on the statute books. Their values were not our values, the values of the colonialists. You see, one of the things, if you want to understand philosophy, is to, for instance, as far as politics is concerned, is to define the state. You see, because law is an instrument of the state. But before you talk about the law itself, you must talk about the state itself. This state, what sort of state is it? For instance, the South African state is a racist state. It has declared its character. It says we are racists. We don't believe that human beings are equal. We believe that some races are superior and others are inferior. That's the character of that state. They have defined the character of their state. And having defined the character of their state, they have gone on to evolve laws which defend the world outlook of that state. So if a South African sees a black man and a black woman, he thinks it's a disaster, and that the world is going to go up is going to blow up. Of course, if they confine themselves to not allowing black men and women to consort, I wouldn't worry about that. After all, I'm not very anxious for it either. But they don't confine themselves there. This is really just a camouflage. They go further and ensure that 70% of the land is owned by 10% of the population. And that's the real core of racism in South Africa. Ownership of property. I wouldn't care about whether the black man and the white one sit on the same toilet. That's nothing. What does it matter? If somebody wants to monopolize his toilet seat, that's up to him. But the most important thing is the land, the wealth, the ownership of the wealth. Who owns the wealth? The moment you challenge my right of ownership of property, then there we fight, because that's not acceptable to to me. The NRM government is strongly opposed to having laws on our statute books which serve the interests of the minority as against the majority of our people, or which in any way serve to promote injustice or advance backward interests in our society. The place the governments of Obote, I think I'd read that, they have no respect for the rule of law and their record of gross violations of human rights through murders, detentions without trial, tortures, disappearances, rapes, and robberies is not going to be easily surpassed. Needless to say, the interests of the, well, I think I'm, sorry, I had read that. I'm not used to reading the speeches, you know. I always prefer to speak what is in my heart. But I was advised when I came from the bush, I was told that presidents don't speak like that. That we must deliver prepared. So I'm trying very hard to keep to that new advice. Hence, even on that account alone, we should soon after independence have embarked on a careful examination of all our laws with a view to working out a legal system that was meaningful and suitable to the values and circumstances of our people. Just as there was no effort to disentangle our economy from a state of total dependence to a reasonable degree of independence, there was similarly no effort made to work out a legal system that took into account our local peculiarities and the level of our socio-economic development. Even when laws spring from society without being imposed by an outside power, they have to be reformed to suit the ever-changing social, economic, and political conditions of society. The crimes that are being committed today, for example, could hardly have been imagined at the time when we got independence. We have a situation whereby state security organs are used to decimate whole populations. Some businessmen are giving millions of dollars of our scarce foreign exchange to import essential goods for the country, but choose to keep the money abroad and bring nothing home. We have embezzlers stealing public funds at a scale unheard of before. We have smugglers. We have robbers who use guns, which were passed to them by the past criminal regimes, to steal people's vehicles and other property. You see, for instance, on this issue of the past governments giving guns to wrong elements, I can cite the example of Okero, Tito, and Basilio, especially Basilio. Tito was not so active, but especially Basilio. You know, when we were fighting him, and we were in Mitiana area and here in these areas, Katonga and so on, he went to Karamoja and contacted the cattle raiders. He said, if you agree to fight for me, for him, for Basilio, and I give you guns, I will allow you to repay yourselves by capturing all the cattle in the western side of Uganda and taking them back to Karamoja. Imagine a leader of a country bringing known cattle thieves, arming them, and saying that you go and you will reward yourself by the loot you get. You see? And he gave them quite a huge chunk of guns, and these are the guns we have been recovering from the cattle raiders in Karamoja ever since. So far we have recovered something like 3,000 rifles from the Karamojong cattle raiders, and yet there are still others at large. Now this sort of situation needs an appropriate law. You cannot just use these ordinary laws to deal with this type of situation after you have inherited the state from such primitive elements. Imagine if I was to call the condos in Kampala and say, condos, please, ally with me so that I fight the rebels in the north. Then at the end of the day, you keep your guns and you repay yourself with those guns. And I am being described as a national leader, even for 5 minutes. That's a real disaster for Uganda. To have that type of leadership, even for 5 minutes. Because in 5 minutes you can do a lot of damage. You can sign dangerous decrees and so on. Now, having had such leaders for not 5 minutes or 1 hour or 1 day, but for 24 years, is a real disaster for Uganda, and we need special efforts, not least in the legal section. We have people who deliberately undermine the unity of the country by openly promoting tribalism and advancing other sectarian tendencies. In some cases, you find there are no laws to cover such cases, and where such laws exist, sentences do not have enough deterrent effect. For instance, tribalism and sectarianism. In the past 20 or so years, it has been regarded as politics. If you can manipulate the tribes, you can manipulate the religions, then you are a fine politician. You are a clever politician. That's what Obote used to do. He used to call himself a master politician because he was a master intriguer. Because he was a master of intrigue, therefore he was a sublime politician. Now, that's where Uganda has got where it has got. You see? The law must therefore be reformed to accommodate such changed conditions in our society. On the side of criminal law, our laws must be made potent to deal effectively with crime. It must be made abundantly clear to everybody that crime does not pay. You know, when I grew up in Ankole, in the Chinyankole language, they used to say, if somebody annoyed you, you would say in the Chinyankole language that eshikijuru ekatano. That is to say, well, if you want to translate it literally, it means European rule saved fools like you. Because if it wasn't for that, I would have killed you. But because I fear to be killed, because you know, actually these African languages are richer than even some of the foreign languages. Because in a very few phrases you can put a lot of meaning. So in that simple phrase, all these are contained, that first of all, European rule saved fools like you. If it was not for European rule, I would have killed you. But since I fear to be killed, when I kill you, then you are saved for today. That's what that simple sentence, Eshikijuru Katamba, means. It meant. That meant that the Munyankwe would have killed you if it was not for the fear that he would also be killed if he kills you. Now that means what? That means that the law then had a very strong deterrent effect. In the past, for example, embezzlers have risked imprisonment so that after they have been released, they can freely enjoy their ill-gotten gains. Incidentally, also another interesting thing among the Banyankole, among whom I grew, as far as the law is concerned, they used to say that if you kill a person, the Europeans would go get head of the deceased, make it talk, so that the head tells them exactly what happened, you see, so that you could not escape. They used to say that, that is to say, they would make the head of the murdered man talk, and they believed that there was a machine which could make the head of the dead man talk. But this was because of the effectiveness of the investigation machinery. Because the investigation machinery was effective, even though you tried to dodge, you would be found out. And to the ordinary people, that would be because the head of the dead man has been made to talk. and it has revealed all the details about what happened, and therefore you are prosecuted and convicted. So those two things, effective investigation and deterrent punishments, can preserve law in a society. The law must be reformed so that not only will they serve long periods of imprisonment, but must also on conviction be ordered to repay all the money they have embezzled. If they have consumed it, their property must immediately be sold to realize it. The same must apply to other crimes such as smuggling. A person convicted of smuggling must not only be made to serve a long period of imprisonment, but must also have his property confiscated by the state in equal proportions to the smuggled property he sorted out of the country. The sentence for misuse of office for personal gain is very light. It must be increased by sentencing the offender to a long period of imprisonment and by taking away his ill-gotten gain through selling his property. Yes, if you misuse government car, you calculate how much damage you cause the state, and we sell your property, and we recover our money. Not just lock you up and things like that. These are relevant because the state has lost. What does imprisoning you help or dismissing you? The money has been lost. The state wants its wealth to be brought back. You caused it a loss. You must pay. This is my simple man's logic. There is at present no offense covering a public servant who neglects his duty and causes loss to the public. Now, this is the most infuriating part. This offense must be created, and any person convicted of it must not only serve a long period of imprisonment, but must also compensate the public for the loss incurred. Partly through the impotence of our laws, criminals have been encouraged to commit crimes, and so it has been left unprotected. The NRM government is determined to use strengthened criminal law to defend our people against embezzlers of their money, wreckers of the economy, and other criminals. Our criminal law at the moment leans too much in favor of the criminal and overprotects him from the consequences of his criminal action. It has been said that it is better that 99 persons go free than that one innocent person be punished. I'm told this is one of your dogmas or principles or whatever. A person with humane feelings does not take pleasure in the punishment of an innocent person, and this should be guarded against. But it would be foolish, in my opinion, to risk setting free 99 criminals who may be murderers or robbers in the scrupulous endeavor to save one innocent person from punishment. So in other words, I don't agree with that dogma that it's better to allow 99 criminals to go in order to protect the one innocent person in this crowd of criminals. If our society is wrecked by criminals, let loose on it, even that innocent person may not be saved. In this connection, the rule which presumes an accused person to be innocent until he is proved guilty should be re-examined. I'm not saying it should be scrapped, but I think it should be re-examined. There should be some other control somehow. Long usage, this rule has become so natural that it appears as if it was ordained by God. It is in fact not universal and does not apply in many countries. That's the fact of the matter. We have discarded other things which also appeared natural, such as hundredweights, stones, gallons, pints, etc., in which we were drilled when we were young. We are now using the kilograms and other things. I believe we can discard this rule too. This rule of presumption of innocence has the logical consequence of placing the burden of proof on the prosecution. And this burden is so heavy that if the prosecution does not prove its case beyond any reasonable doubt, the accused will be set free. The accuser does not have to say anything in his own defense. He can just keep quiet. I can just come in court and I say, look here, you are the one who's accusing me, prove that I'm guilty. And I just keep quiet, and then it's up to you. If you fail to prove that I am guilty beyond reasonable doubt, then I'm free. This, in my opinion, is wrong and goes contrary to our traditional concept of justice. A person, you see, I am fond of quoting Banyankole proverbs because I'm so steeped in that culture of those gentlemen. But it is so rich with so many philosophical and legal. Those Banyankole are going to say, they say, that is to say, a peasant loses a sheep, his sheep gets lost. Now, when the sheep gets lost, and these are philosophical and legal concepts evolved by those gentlemen and ladies in that part of Uganda. Now, somebody loses a sheep, condor. Then, at the same time, a hyena passes excreta which contains hairs of a sheep. Now, according to the Nyankore, that hyena is guilty. Why? You see, this was the traditional. This was the traditional concept of guilt among those gentlemen, because my sheep got lost, and roughly around the same time, when my sheep got lost, a hyena passes excreta with some hairs of sheep in his feces. Therefore, the hyena must be guilty. A person accused of an offense always defending himself in some of the traditional societies. I'm not very familiar with all of them, but definitely like the one which I'm very familiar with. You have to defend yourself. You could not just sit there and just say it is up to the accuser to prove your guilt or otherwise. In fact, the more unwarranted the accusation, the more the accused will have to speak in his own favor. Even with societies which have a perfect machinery for investigation and prosecution, this rule is not good. With us, however, it is absurd because we don't have a good machine of investigation. We don't have. The other day I was talking with a certain foreign diplomat, and we were comparing notes. We don't have lie detectors, for instance. Do you have lie detectors in the police department? Because in America now they have got machines called lie detectors. When you're interrogating somebody, you can have this machine which can show you that this man is telling lies. Or otherwise, I don't know what they have them here. We don't bar people's houses. We don't have electronic eavesdropping capacity, which the Western countries have. They can just listen to you in your bedroom, wherever you are. So really, we are putting a very big burden on the police, even if the police was good, which of course is also not good. But assuming it was good, it would still be a difficult job. So if you use ultra-modern concepts in a backward situation like this one, you could cause problems for yourself, for your society. It guarantees freedom to a bigger percentage of criminals who are brought to trial. I think it should be changed so that an accused also has a duty to defend himself. I'm not saying it should be entirely scrapped, but let's examine it. Let's be open-minded about it. should not necessarily be required to prove his innocence beyond reasonable doubt, but he should be required to defend himself. In a situation where the government is fully committed to the rule of law, the state has no interest in persecuting innocent individuals. Usually the person arrested by the police or members of the public is not entirely blameless and has something to answer for. People cannot really just arrest you for nothing. Even the Europeans have got a saying that there is no smoke without fire. I think that was also evolved because of their own experience. In the event of a mistake being made, the accused can defend himself in court. The court, after all, plays the role of arbiter between the prosecution and such an individual, and it can satisfy itself that he is innocent without calling in its aid the hacking statement that the prosecution has failed to prove its case beyond any reasonable doubt. Bail is another area of our criminal law which must be re-examined. On this bail, I've been having a lot of difficulty with our soldiers. They cannot understand bail. They really don't understand, and even yesterday I was explaining to them. Somebody was found with a gun and he's bailed. That some law says that legal possession of a gun, illegal possession of a gun is not is a bailable offense. Really, this is discrediting the legal profession in the eyes of the National Resistance Army. This I can tell you separately. These fellows are saying that these chaps are not serious. What was he doing with the gun? And why must he be bailed? You see? How many people will die because of this? If a man had a gun illegally, what did he want it for? For some crime, political or criminal. Now, why should this man be bailed? The National Resistance Army people cannot understand this. You see? They cannot understand that. They are completely perplexed by all this. Members of the public go to great lengths, sometimes even risk their lives. Our committee men risk their lives to arrest, to report somebody with a gun. He is taken to court, 2 days, he's bailed out. And as far as they are concerned, he's freed. You see? In fact, recently I had a very interesting case. One old man had his cows had been stolen by some other person. Then eventually he found the cattle. So they were taken to the police station as exhibit. And being taken to police station as exhibit, they are put there in the town, you know, to stay feeding on the casasol in the town. Then the man, the thief of the cows, was released on bail. So this old man came and asked me, who has committed the crime, the cows or the thief? You see, because according to him, the cows were in prison, they had been in prison. And the thief was at large. You see, it could not make any sense to this old man, and I could not answer him. You see, this is the sort of danger you can find yourself feeling these half-baked. So these members of the public go to great lengths, sometimes even risk their lives, to apprehend a criminal, only to see him walking a few days later a free man that has been bailed. They are told in disbelief that he has been released on bail. Immediately, the accused sets about destroying the evidence by bribing some key witnesses or threatening them or liquidating them altogether. And our police is not all that efficient to protect everybody. Our police is not efficient to protect all our witnesses. It is not omnipresent. It's not omnipresent. Somebody can go and kill somebody in the villages. As long as he's got a gun, we don't have a police to cover all our population. his chances of ever being convicted become very slim indeed, more so when this is coupled with the burden of proof on the prosecution that is ever so high. The Attorney General and the Law Society should do research on this and find out how many accused persons are convicted out of a total number of those who are released on bail. You could carry out a research. If you are released on, those people are being released on bail, how many of them eventually get convicted? This is ascertainable. You can find out exactly this ratio. I have no doubt myself that the percentage is very low. The moment you are released on bail, then you have got freedom of tampering with the evidence and intimidating witnesses. The rule which prohibits creations if offenses or enhancement of sentences retrospectively is something that should be reconsidered in the light of gross violation of human rights that we have gone through. I am still aware of the Law Society's vehement opposition to the Human Rights Bill of 1980, which sought to punish those who belonged to Idi Amin state organs of murder and terror. You opposed it, among other things, on the grounds that the bill was retrospective. I believe that if that bill had been enacted into law, we would have been spared some of the atrocities committed by Obote's security organs, or at least we would have had a ready law to try those who used these organs to perpetrate atrocities against the people. As it is, we now have no law to try such people just because of some principles which is regarded as sacrosanct. Our responsibility to our people is not only for the future, but also for the past and present. People see with disbelief those who terrorized them walking freely and cannot understand why they should not be prosecuted. It should be realized that failure to redress such grievances results in people taking the law into their own hands or in loss of confidence in the government to which they look for remedial action. We have got to act. You see, because we are not going to guarantee the future without punishing the past. For instance, although this is politics, I have been subjected to some pressure from some quarters saying that we should pardon all the criminals of the past. This is a man of God. He's a bishop. I think he hopes to go to heaven before I do. I have met this gentleman twice. First it was in, I think it was March or April when I went to Gulu. Then recently in December when I was there. Every time he comes to me, his emphasis is to forgive the criminals. Then I asked for Ogwar. I said, Mr. Ogwar, if I forgive those who killed in 1974, in 1972, in 1980, in 1981, 1983, how will I then punish those who are committing crimes today? How can I punish the soldiers of the National Resistance Army who are committing crimes when I have forgiven the ones of the UNRA and the ones of Uganda Army? How? Will it be that the criminals who supported me politically will be punished and those who oppose me politically will be forgiven? That will be the only logic. So, and I told Mr. Ogwar that if you are really interested in re-establishing peace here, there cannot be any criminal excused on political grounds. All criminals must be punished. That is the only way we can establish peace for the future. That's what people are doing in Argentina. I think you hear the situation in Argentina. They are going backwards and getting hold of all those chaps. Former presidents, former this, they get hold of him. I'm not threatening. But so that you see, if we do not punish the criminals of the past, I can tell you it will be difficult to guarantee security in the future. It is not easy to guarantee security for the future without punishing the past criminals. At least, even if you don't punish all of them, you can excuse some of them depending on the degree of responsibility of crime. But to say that all of them should be excused unconditionally is very unwise. It will endanger the future of our country. When I addressed the seminar on the administration of justice last month, I talked about the problem of legal technicalities. This is the one factor that is widening the gap between justice in the popular sense and justice according to the law. In my opinion, justice is indivisible and there cannot be categories of it. If, for example, a murderer or a robber escapes punishment because of some legal technicality, there may be justice according to the law, but to all intents and purposes, there has been no justice at all. Because in reality, injustice has been upheld by a court of law because the criminal has escaped. And people know that justice has not been done. They know it, the population know it. They do not have to be educated to know this. Contrary to what some people believe, popular justice does not mean justice which is impure or tainted or perverted. Nor does it mean mob justice. It simply means justice which people appreciate and understand. If justice continues to be administered above the heads of our people, they are bound to demand an overhaul of the system so that they get in its place something that they fully appreciate and that conforms to their ideas and values. We must therefore ensure that technical rules which hamper the proper administration of justice in our courts are reformed. As much as possible, we must ensure that cases are lost only on grounds of merit and not on technicalities. Really, you are doing a harm to justice if you throw out a case, in my opinion, as a layman. Because me, I'm in the crowd, I'm among the masses. I'm just there among the crowd where I shout, Chilokitufu, this is right. This is my sense of justice. If you throw out a case just on technicalities, I'm sure I'm doing damage to the courts and to the justice itself. It is not just to throw a case out of court, for example, because the plaintiff does not disclose a cause of action, or the charge is defective. Opportunities must be given to amend the document so that the court proceeds to hear the case on its merits. What's wrong if the thing has been written bad? You go and write it again. I should also like to see the rigid separation between a criminal court and a civil court dismantled so that there is no undue delay in getting redress from the court. As I said earlier, if an embezzler is convicted of embezzlement, he must repay immediately the funds embezzled, otherwise his property should be sold to realize the amount embezzled. Similarly, I should like to see a citizen who is wronged or injured by a criminal compensated by the criminal immediately in the same court, which convicts him. After all, witnesses are the same, and I see no good reason why the victim should have to wait for the criminal to be released from prison, which may be many years, in order to bring a civil action in court. You see? The NRM government is opposed to justice being a preserve of only the rich and the educated. It must be made accessible to all the people. Because of legal technicalities, an ordinary person can hardly present a case in court. At the same time, he cannot hire the services of a legal practitioner because we have become too expensive. So he's helpless. It is only the rich who can afford to pay for your legal services and for whom you will use your accumulated knowledge of legal technicalities to win cases usually against the poor. In what sense, then, can we meaningfully talk about equality before the law if the lawyers and the courts are only at the service of the rich? You have a duty to society which educated you in the first place and enabled you to get this high training. You should therefore make your legal services accessible to society as a whole and not just a small fraction of it. You should lower your fees so that justice can also be accessible to the ordinary person. The law at the present is that you should not undercut by charging less than the fees set out in the scale of charges. The law should now should be that you should not overcharge by charging more than the fees set out in the scale of charges. The new scale should immediately be worked out by the appropriate authority. Some countries have legal aid schemes where legal services are given free of charge or at a nominal fee to those members of society who may not be able to afford lawyers' fees. This is something which the Law Society, in conjunction with the government, can establish in this country. I'm glad to hear that you are really talking about it. But the Law Society should play the preponderant part. Every lawyer, for example, can be required to put in 1 day in a month to give free legal services to the poor, which you have already agreed to do. The scheme can also mount a program on the radio, in newspapers, community centers, schools, women clubs, etc., to educate the people as to their legal rights and obligations, so that some people do not take advantage of their ignorance of the law to exploit them. Because of the problems inherent in the law that we adopted from the British, such as complexity of evidence and procedure, corruption in the courts, delays in hearing and disposing of cases, and of course costs of litigation, the National Justice Council is soon going to enact a statute giving judicial powers to resistance committees to hear cases that are common in the countryside, such as land disputes, cattle trespass, simple assaults, thefts, etc. The committees will exercise these judicial powers at village, Muruka, and Gombora levels. Cases will be heard expeditiously, as the procedures will be simple and no fees will be charged. These committees have been operating in a judicial capacity even before the enactment of this law, and they have so far been doing very well. In fact, recently I saw a man from one of the districts, and he told me that the police are now very hungry. I'm really amused by the philosophical capacity of the people. These peasants, maybe you don't talk to peasants, but me, I talk to peasants. I'm great to deal. And they are very clever people. Now this man came and told me, of course when I translate it in English, it means meaning, when he's speaking with the vernacular, it's very precise. And he said the police are now very hungry. And if he's your friend, you can have pity on him and give him a bunch of bananas. That's the only thing you will enjoy. I said, why? He says, because the committees are settling all the cases. You see? They're settling all the cases. So the policemen are completely unemployed, and their services for which they were getting some pecuniary rewards are no longer needed. So I really, so these committees are already exercising judicial powers de facto. The other day, the Honorable Njuma was trying to rein them in because they are de facto taking over the powers. Any possible weakness that is discovered in due course shall be immediately corrected by an appropriate amendment to the statute. We also intend that those who apply to court, for instance, before I leave this section, I wish to acquaint you with our experience in Luero, here in the bush. At that time we were controlling all the Gomboras in Nakaseke County, or some of the Gomboras in Chadondo, like Gombe and Nyimba, some of the Gomboras in Busiro, like Masurita, Kachiri, Wakso, Namayumba, I think Namayumba is also in Busiro. And half of what we call single, that is to say the Gomoras of Busunju, Chikandwa, Bukomero, Wamata, Chiwoga, Bukwiri, and a bit of Kasanda and Bukuya. So, and then we also controlled some Gomoras in Wabsana, that is to say Chichusa and all that, and part of Burudi. This was a big area. And in 1982 we worked out, which you could look at actually, we worked out a legal code for our area. And roughly it was like this. All criminal and civil cases, other than murder and treason, were tried by the resistance councils. Very simple. Murder and treason were tried by the High Command. Were tried by the High Command of the National Resistance Army, and I was the chairman of the of the High Command. So I was the Chief Justice. And the thing was working perfectly well. You see, perfectly well. Certainly the murder cases were very few. Hardly you could get a murder case. Hardly. You could actually do research in this because the records are there. You can just go and carry out an exercise, you as people who are interested. We also intend that those who apply to court for letter of administration to be given authority to administer the estate of deceased persons should pass through the chairman of the resistance committee of the village and parish in which the deceased resided. Notices of application appearing in newspapers which are only confined to Kampala. Now imagine, you give a notice that somebody's estate is going to be divided up, and it is put in a newspaper in Kampala. And this man is living in Chikamulo, or Kabogwe, in Kapeka, or in Adlan, in Achuri. Do you really think this is serious? These notices are not enough. We would like interested persons in the village and parish to know that someone has applied to administer the estate so that if they have any objection, they can raise it immediately. The committees can also be tremendous, can be of tremendous help to the Administrator General in his work of administering the estate. There is a lot that we could have learned from our customary laws if we had cared to create, soon after independence, an independent and suitable legal system in this country. Enforcement of African laws and customs depended on two principles, namely, reliance on the parties concerned to accept the judgment of the elders and on the fear of upsetting the balance of nature or the community, either of which might lead to the destruction or punishment of the wrongdoer and defaulting party. While the African legal systems recognized the place and value of the individual, that recognition was invariably linked with the sustenance and survival of the family and the community. The interests of the latter always prevailed over the claims of the individual. This was a political and legal concept to be taught and memorized by every African child. The superiority of communal interests was so well embedded in society that any individual who defied it was instantly punished, more often than not by his own close relatives. There were, of course, some weaknesses and gaps in our customary law. It was not an advanced system as far as commerce and technology were concerned. Its rules relating to the identification of certain wrongdoers left a great deal to be desired. But its emphasis on confining the settlement of disputes among the immediate families, clans, and elders of the respective parties encouraged the understanding and respect for the law as well as cohesion within society. Thus, there is much good which we should not allow to disappear altogether in the name of catching up with civilization. I would like the Law Reform Commission, as a matter of urgency, to come up with proposals concerning the new marriage and divorce law so that we can get rid of the present law of marriage and divorce. It is absurd, in my opinion, that we should be having this law, which was passed in England in the 19th century, on our statute books. Even England has since drastically amended this law, but we, who should not have had it in the first place, are still applying it. This law, which forces every man to marry one wife, and also every wife to marry one man, and which gives to the man only one ground for divorce, i.e. adultery, or which requires the woman seeking divorce to couple any other ground with adultery, is an African and contrary to our cultural values and traditions. Why should a man be forced to remain, for example, with an intolerable lazy or insolent woman who may not have committed adultery? Why should a woman whose husband turns out to be a tramp, who is not interested in sex, not be allowed to divorce him? For instance, suppose the husband becomes a vagabond, but he doesn't commit adultery. What do I do with the poor woman? You see, I'm forced to stay with this vagabond all my life according to this law. This law should therefore be changed to bring it into conformity with the values of the people. Our land law is equally in need of urgent reform. The present law is still very weak and does not give sufficient protection to tenants from being improperly evicted by absentee landlords who claim all of a sudden that they want to develop their land. It is also known that some people used their government positions in the last regimes to acquire land titles, and that others bribed officers in the land office to acquire land titles in respect of land held under customary tenure. Actually, this is a very big problem in many areas now, because we have got squatters there, thousands of them. And this man went to the land office, and through arrangement with his friends in the land office, he got pieces of paper claiming that that land belongs to him. While they never came to do on spot inspection to see whether the land was settled or not. This is giving us a lot of headache in some of the areas. People who were legitimately living on such land were summarily evicted, and the land is now owned by these unscrupulous individuals who used improper means to acquire the land but who have titles. I think the law should be amended to allow such ill-acquired titles to be cancelled so that the land reverts to its rightful owners. Let me now talk about a matter which concerns you as legal practitioners, but which may not be directly connected with the law reform. I have been informed that some legal practitioners are corrupt and that they bribe police, magistrates, and even some judges. I am sorry to go so far, but we have had it through our reports. Certainly for magistrates I know, about the judges I'm not so sure. It has been said elsewhere, more in jest than in earnest, that there are two types of lawyers: those who know the law and those who know the judge. In Uganda, this may no longer be a joke. Some lawyers, it is known, try to ensure that their cases are heard by a particular judge, and in the process seek unnecessary court adjournments and even go further to interfere with the registry. This matter is irregular and should be stopped. It is also known that some lawyers bring cases to court without getting instructions from clients, and some even steal clients' money. Those lawyers who perpetrate such illegal acts may not be many, but they tarnish the image of the whole profession. I am therefore calling upon the disciplinary committee of the Law Council to be more vigorous and resolute in punishing severely those lawyers guilty of professional misconduct, so that such unethical behavior can be brought to an end. It has been said by some lawyers that lawyers are not judges and that their role is to present the facts of the case before the court as objectively as possible and leave it to the judge to decide one way or the other. If this is what is supposed to happen, then it is a disservice to society. A lawyer has got a conscience and a duty to society. And if in the process of his instructions, he should be convinced that his client, the accused, committed the offense, he should advise him to plead guilty. Yes. Why not? Why not? If he refuses to do so, he should decline to take his instructions. I can tell you that would enhance your reputation as lawyers. Because now you are taken as clever people who know how to manipulate things. You are not really taken as, when they say Prida in the village. Prida means a very clever man who knows how to turn black and white. This is the reputation we have. I would prefer you have the reputation of people who bring out the truth. If it came that lawyers are the people who bring out the truth, I can tell you your standing would go very high in society. In practice, however, even when certain lawyers are convinced that the accused committed the offense, they throw themselves heart and soul into the case, devise all sorts of defenses, mislead the court, and intimidate witnesses through cross-examination, with the result that the criminal sometimes escapes justice. Lawyers should re-examine themselves in this respect and stop aiding crime. Let me finish by affirming that the NRM government is totally committed to the rule of law and the protection of human rights in the country. Any problem that may appear in the enforcement of the law is temporary and will be ironed out. Anybody, whatever his status, who breaks the law will be punished. Even in the north of the country, where we are still fighting, the rebels, our soldiers have strict orders not to molest civilians or touch their property. Incidentally, I should say a little bit about this because of late, there's been a barrage of criticism from, first of all, Mr. Wal, the Bishop of Guru, and secondly, all sorts of the newspapers, papers which are manned by very ignorant chaps, sub-quality journalists, who all of a sudden set themselves up as strategists. I can tell you that our line is very, very clear as far as human rights is concerned. In the National Resistance Army, we have got two codes. One is called the Code of Conduct, which was published under one of the legal notices. It's clear, you can read it. One is called the Code of Conduct, which governs our troops when they are not in operations, when they are in barracks or in normal times. Everything is laid out there. The second code is, we call it the Operational Code of Conduct. This is the code of conduct which governs troops when they are fighting or they are in operation. They are all well laid out there. Anybody who infringes any of those provisions is punished severely, including execution. And moreover, since we came into power, we have arrested many soldiers and tried them. There's a general court martial which tries all these soldiers. There is what we call unit disciplinary committees, UDC, for every battalion. They try all these cases. Moreover, in the case of the North, we have established what we call a liaison officer at every brigade level. The job of this man is to record all complaints from the public. Any member of the public who is offended should immediately come and report to the liaison officer, who has no other job except to receive those complaints. And then he tells the commanding officer to immediately investigate all this. So there is no way a crime can be committed by our soldiers, and nothing is done about it, unless those against whom it is committed do not report it. So there is no question of us violating human rights in the North. However, we are duty bound to defeat the enemies. There is no, I will make no apology for this. As long as there is anybody who takes up a gun contrary to the wishes, to the orders of the National Resistance Government, National Resistance Movement government, that fellow will be defeated by force of arms. So if you take up arms, we shall deal with you with arms. And don't start squeaking when we get hold of you. So some of these fellows, like this bishop, have been the ones finding problems. And businessmen here in Kampala, businessmen, who know them? Owners of this, they own very big businesses here. Now they think their businesses are in danger because they got them wrongly. And they have been funding our poor brothers in the North to take up arms. And once you take up arms, we deal with you. You, the armed man, not anybody else. There is no question of us violating human rights. How? Because for us, our line is very clear. We kill only the armed person, as long as he's still armed. The moment he surrenders, that's the end of the story. We have not even prosecuted those who surrendered. We captured a total of 15,000 soldiers of Uganda National Liberation Army. We captured them. We organized them in Fort Potro, in Mbarara, in Kiburara. Some have been absorbed in the army, many have been absorbed, some have been sent back to their homes. You as lawyers, you can go to Kiburara today, Kiburara prison farm, you will find these people there, being reorganized. So if we do not kill those, why should we kill anybody else? So therefore, if these critics are saying that we should not defeat the rebels with arms, then we are not going to accept that. If they are saying that we are violating human rights, that cannot be true, and it's not true. And whoever does it is punished. In fact, the High Court had to go from here to Adlang. Adlang is a place in East. In fact, the people of the human rights should accuse the courts. They are the ones. There's a man who killed a chap called Biaranga. He killed Manainchi in Adlang. I think this was last year. For us who arrested him, we would have dealt with him under our code. But at that time, we had not amended the document to legalize our courts according to the state law of Uganda. So we used the civilian courts. And the High Court went up to Adlang in East Acholi, in Kitgum, and sat there. And to my, well, I don't know if it would be regarded as contempt of court. What are my rights in this? Can I make a comment? It's allowed. To my indignation, the High Court handed only 10 years to this gentleman. Because they said that he was under the influence of liquor, and it was the liquor which was responsible for killing the man, not the man himself, that this led to diminished responsibility. But for us, our way of dealing with him would have been very different. Because for us, we don't see why you should be drunk in the first place, especially when you are carrying weapons. So I don't see how anybody can turn up and say that we are condoning the committing of crimes. It's impossible. The record is very clear. Since we captured Masaka, we captured Mara, we captured thousands of these fellows who had been fighting us. This is when I've got a saying, I've got a name. You know, if you are so liberal, they call you Afandumi. That is to say, things go bad while you are just watching and you do nothing about it. We cannot adopt that attitude of letting wrong people commit crimes and go free. You see, because if you are serious, you as lawyers, or anybody who is talking about human rights, he should analyze the objectives of those rebels. What are they? Because you cannot have a war without objectives. A war with objectives you can have those objectives as justified objectives or unjustified objectives. If your objectives are justified, then we can accommodate you politically. We can say, okay, what are your political objectives? You say these are the ones. Oh, these look to be justified objectives, even though we differ from them. So you come and we discuss politically and we accommodate you politically. But if you are fighting because you do not want to be punished for the crimes you committed, now how can we handle you politically? What do we say? Do we say, come back, Mr. Museveni, we are not going to ask you about the man you killed in Luweero, we are not going to ask you about the property you looted? Is that ensuring justice and security for the future? I don't think so. If those chaps had a justified political case, we could have dealt with them politically, we could have negotiated with them or what. But they don't have. The argument is that they killed people and they don't want to be prosecuted. And the only way they can escape prosecution is to be in power. Because when you're in power, you are not prosecutable, according to them. You see? Now, we cannot accept this. So therefore, this business of saying that there is any violation, there could be some mistakes. There are some mistakes in some cases. But these mistakes are always punished, and severely. You see? And we can inform, we can give copies to the law society every time we punish a soldier. It is said that in every basket there is a rotten potato. We also have some members of the NRA who do not comply with the NRA code of conduct. But as soon as we discover them, we punish them with families. Therefore, we shall ensure that the rule of law is restored and maintained so that we can re-establish social justice and assure economic development for our people and our country. Thank you very much.